Okay, this was going to be a quick one. We are in our employment law book, chapter 15, labor law, page 867. So, we're going to be talking about a labor law. Four main federal laws constitute the statutory basis for labor law and unionization. The legislation initiating a move toward collective bargaining in the United States began with restricting court responses to union activity and establishing the rights of employees to form labor organizations and to be protected against unfair labor practices at the hands of employers. So, that doesn't require too much explanation. We know what went on with the unions in the past. Everything from intimidating employees to join or move in the way that they wanted. Corruptions existed. So it's definitely an issue, something that needed to be addressed. Okay, so next they move on to the until the Norris-LaGuardia Act of 1932 and the Wagner Act of 1935, generally referred to as the National Labor Relations Act of 1935, employers had held virtually all the power. However, once that right to bargain collectively was created and unions were established, the matter took some rather sinister twists. Unions started feeling their power and often went overboard in using it. So we were just talking about that. And they got involved and taken over and infiltrated by all sorts of unscrupulous demographics. So, this resulted in two other legislative measures to address the evolution of collective bargaining. The Taft Hartley Act, also known as the Labor Management Relations Act, amended the Wagner Act of 1947 to establish unfair union practices, and the Landrum-Griffin Act of 1959 gave certain civil rights to union members and addressed corruption of union officials. So that's my first portion. That's our employment law explanation, first excerpt. We're going to continue later on in this chapter, and then we're going to also look into it in our HRM book. So that will this is going to be a 3-part series on the Taft Hartley Act.